Good morning. It is 10 a.m., November the 22nd, and the Texas Appraisers Licensing Certification Quarterly Board meeting is called to order. We will start the meeting with a Pledge of Allegiance led by Laurie Fontana, and the Texas Pledge by Mark McAnally.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state under God, one and indivisible.
Agenda item 2 is roll call and discussion and possible action to excuse board members that are absent, if any.
Chairman Walter Beer.
Present.
Jamie Whitworth.
Present.
Roy Fontana.
Present.
Luis L. Gardner.
Present.
Mark McAnally.
Present.
Keith Kidd. Shannon McClendon.
Present.
Clayton Black.
Present.
Present.
All present except Keith Kidd, and Keith Kidd is on active duty and has let us know that, so we wish him well in his military career. Agenda item number 3 is ratification of the official record of the August 16th, 2013. I'm
Mr.
sorry.
Chairman, do we need to move for an excused absence for him, or just you noting it?
I think we should move for it.
Then I would make that motion to move for the excused absence of board member Kidd.
I'd second that.
All in favor?
Aye.
Opposed? Motion carries. Okay, agenda item number 3, ratification of the official record of August the 16th, 2013, board meeting as approved for posting on the website by the Secretary of the Board.
With pleasure, I would like to move for approval of the minutes without any corrections.
Do I hear a second?
Second.
All in favor?
Aye.
Opposed? The motion carries. Okay. Agenda item number 4 is public comments from members of the public regarding non-agenda items, and we have one person, Mr. Kenneth Jones. If you will come forward, and what is it, 3 minutes? And Mr. Jones, we have always allowed 3 minutes.
I probably won't take that long.
Okay.
I'm Kenneth Jones. I'm a practicing appraiser in Fort Worth, Texas. And I have had a disciplinary action against me. I fulfilled all the requirements of that was required of me to be in good standing again. I have a letter stating that I'm in good standing. However, I still appear on the website, as do another appraiser in my office who was under the same situation. We still appear on the TALCB website as having disciplinary actions against us. So I wanted to see if there was a way to either get removed from that list now that we have the letters that we're in good standing, or have that something stated or noted that we are back in good standing.
Great. Can the Commissioner, could you give us a comment on what the normal process is for getting people off of that list?
The record that appears on the TLCB website is of all disciplinary actions approved by this board over, and I believe the record retention and display time for that is approved by the Library and Archives Commission on our is 10 years. So we'll actually, the official record of disciplinary action by this board remains displayed on the website for a period of 10 years. And it's clear that that Mr. Jones and others similarly situated in good standing. The official record for that is the National Registry, which is linked from our website. But any agreed orders entered into by the board with the appraisers, you'll see them as far back as 2003 on the board. That's been the board's official policy for as long as I've been aware.
So is there any way to have some additional notation made saying that we're back in good standing?
Yes.
I'd like to just, if the appraiser has completed his work, his disciplinary work, the official record has nothing to do with posting of the record. We can have an in-house record that is officially documented and has everything, but to continue to punish the appraiser because he's completed a disciplinary action doesn't have to be posted, in my opinion.
I hate to interrupt, but this
Can you use a mic for us, please? Sorry, Mr. Chair.
Should we continue to discuss it?
Is that better? This is public comment item. If we want to have discussion on this item, we need to set it as a future agenda item, and then you can have all the discussion you want on it.
Okay.
Thank you very much. And
Thank you very much.
While we're saying that, General Counsel, I think it's important for us to note, if we are going to put it on an agenda item, that it gets noted immediately, that it will be put, not to have to wait till the end while we have
Right.
accumulation.
Right.
And the second thing, this may be for an emergency meeting, because if we've got appraisers out there that are losing income right now because of a posting where they've completed it and we don't meet for another 3 months, I would like for General Counsel to look into an emergency meeting for this and see if there's a way for us to do it when we've got some serious public concern. I have serious public concern that someone go 1 day longer with that posting. I am totally familiar, General Counsel, with retention policies and in fact very familiar with record keeping, but the posting, I think, by comment by Mr. De La Garza is exactly right.
Mr. Chair, can council keep us posted, on Ms. Shandon's request?
Yep.
And let's move on that quickly.
Absolutely.
And if it needs to be a motion, I second it, and let's,
Can't make a motion.
We can't really do anything with it.
recommendation.
We'll look into it and follow up.
Thank you very much.
She'll let us know. Agenda item 5 pertains to enforcement matters, and we're going to go into executive session. The time is 10:08. The board will now go into executive session on agenda items number 6 and 7 to receive advice of counsel concerning pending or contemplated litigation settlement offers, enforcement actions before the board as authorized by Texas Open Meeting Act. We anticipate returning to open session in approximately 20 minutes.
Speak up more better.
Okay, it is 11:02, and this meeting is back in session.
Whoa, excuse
All
me.
right, where were we here? We are on agenda item number 6. Discussion on possible action to approve agreed final orders and surrenders in multiple matters.
Mr. Chairman.
Oh, I wanted to make one comment, is that a lot of these things today will be grouping, and if you have an individual item you would like to speak on, then you need to let us know. It'd be great if you let us know right now so we could make sure you're you're recognized, and fill out a form. We have forms you can fill out, and we'll go from there.
So To expedite, if I,
Yep.
I could, Mr. Chair, and Troy, take this as a compliment, I think. But I would like, based on our executive session and that kind of thing, I'd like to go ahead and move for the approval of the agreed orders and the surrenders under item number 6. That would be, right now it's listed A through L. I would like to move for approval of all of those except for B and I.
A.
And I meant A. I've got A circled.
A and I.
A and I. So my motion is to move for approval of 6B, C, D, E, F, G, H, J, K, and L.
Second.
I have a motion and a second. All in favor?
Aye.
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 Opposed? Abstentions? Motion carries. So,
Mr. Chair, if I
Yes.
may, ask a question about A. Troy, if you don't mind, on page 32 of 301, conclusions of law under the order education, item number A.
Yes?
I was just seeking some clarification on the 14 hours. We have 15-hour USPAP classes and 7-hour USPAP classes. Is there a reason that's 14?
You know, I do not know. I agree with you. 15 hours is norm. I think that the 15th hour is the exam hour. Mr. Wolf actually handled this agreed order, so I don't know if you have any.
This was actually in negotiations with this individual. He was hung up on this number of hours, and I thought, well, the only two that are offered are 7 and 15, so if it wouldn't make a difference. But this was something that he wanted 14 hours in there.
Can I ask you for some clarification, or at least to make it consistent? Because in the above paragraph, there's a statement saying, unless otherwise noted below, all classes must require in-class attendance. If the class requires an exam, respondent must receive a passing grade on that exam. Can we do something to make that consistent? If he's not going to be obligated to take the 15th hour, the 1-hour exam?
Well, it's just how I've written and how I interpret this. It's just a minimum of 14. So if he would have to take the 15-hour USPAP, and he would have to take the exam of how it's written. Typically, the fifth, what?
He could have taken the 15-hour class and simply not taken the exam, and then we've gotten credit for 14. That's the reason we're confused. We think the language is confusing because in the paragraph above it says he must take the exam.
Right, and from my understanding, it's different with most course providers that they will not issue the certificate if you do not pass the exam.
Well, other appraiser members can correct me if I'm wrong, but I think you can sit in a 14-hour USPAP and not take an exam and still get credit for it. But it's dependent on the provider.
Clarification on that. That is if you're attending it for continuing education.
Oh, true.
So, yeah.
Thank you for that clarification.
Yeah, from my understanding, when I took the 15-hour USPAP, they said you will not get a certificate if you do not pass the exam. But I could be wrong. Like I said, some of the course providers do it differently. Yes, sir.
So my question is it a continuing education class or is it a required class that you're asking of this respondent?
On these, it should be in there in that paragraph that it will not count towards the continuing education. You know, the providers don't offer just a remedial education type section, so sometimes they'll take it under the auspice of continuing education, but it's really for our remedial purposes.
So it should be 15 hours for all
Yes, sir.
practical purposes?
Yes, sir.
Okay. That's what we wanted to know. Thank you.
Well, do you think that, may I, Mr. Chair?
Yes.
Do you think that, well, first, you might want to identify yourself for the record.
Oh, yes, Kyle Wolf, staff attorney.
Do you think there would be any problem if we approve this conditionally with changing that to 14 to 15, or do you think that will cause angst?
With just based on negotiations, yes. I mean, I was kind of confused of the purpose of it, and I did not think it would be. I didn't think it would matter because it's a minimum, and he would he would have to take, if he took over that, it's not necessarily a problem, because in a lot of these orders, we just say, we do a minimum so they can't just go take a 3-hour course. So we say, well, there needs to be some kind of minimum, and then sometimes we'll get a 30-hour class back for a 15-hour course. Does that, am I making any sense?
No, you are making a lot of sense, and I don't know how much contact you actually have with this specific respondent, but if we change the, and you don't have it in front of, well, you may actually, if we change the 1A where it says 14 to 15, do you think that the respondent would still sign off on this? Since some, not all of us, I'm just trying to help facilitate here, that since you're requiring him to take a test anyway in the above paragraph, do you think that the respondent would accept that?
I can certainly try. I don't want to sit here and say that I won't try for you, but I would just, with this one, I would like to just move on with it, if that makes any sense, because this was something that he was particularly, like I said, it was kind of an odd request.
So you spent a lot of time with this client, I mean not this client, this respondent, and this is the outcome, this agreed order is the outcome of your negotiations. It wasn't a typo.
Yes, ma'am. And then I think, I think the purpose will still be achieved, because, and I will call Champions in Columbia and find out if they will issue the certificate, if they do that, if they don't pass the exam, if that makes sense.
Mr. Chairman?
Yes.
So are you asking that the respondent take the exam or not?
Yes, yes.
May I just suggest that if it's your understanding that he agreed in this order to take the exam, would it be satisfactory to the board to accept this with that agreement clarified? In other words, if you call him and said, you have to take the exam for this, and he says, well, of course, and exchange that in email, and then this proceed.
Absolutely, I can do that. And I think he understands that, because I did clarify to him this is the national course that requires an exam, not the 7-hour continuing education.
So should we just postpone voting on this one until Kyle gets a chance to go back and ask, or is that just or just a conditional?
Approve subject to that condition that he agreed to take the exam. He believes that's the understanding, that it was clear to the gentleman that he agreed subject to taking the exam, and so if we get that in writing, then this remains approved.
I'd be happy to call him right now, too, and see if I can get an email.
I'd like to go ahead and make a motion to accept it with the condition that he needs to take the exam.
Second. Sorry.
All in favor?
Fourth. Oh.
Pardon me?
I was making not a very good funny.
All in favor?
Aye.
Aye.
Opposed? Laura, you have one more.
Can I ask, Mr. Chair, one quick question of General Counsel? So how do we proceed with this? Is there an amendment to this agreed order, or, what I'm envisioning is a year later, or whatever the time period is, this guy coming back and say, well, I didn't take the exam because of whatever, and we don't have to dig through our conversation here.
Is this on? We would get written approval to do it, and actually, if you look at the wording in it, the 14 hours
says minimum.
Is a minimum, and it says above he must take the class. All that Kyle is going to be doing is verifying that that is his understanding of the agreement. If that's the case, it's written to do that. And that may be why, just speculation, he said, I want 14 hours. I know I got to take the exam, but I don't want you to think I have to take 15 hours plus another exam. I don't know what the logic could be in the negotiation. But if he gets verification that he understands that the 14 hours is the course, plus he has to take the exam that goes with it, then it's written that way.
And that verification will be kept in his file or something like that?
It would be kept with the order.
Okay, perfect. That's what I was asking from him. Thank you.
Thanks, Kyle.
Thanks, Kyle.
Thank you, Mr. Chair.
Mr. Boyer, if I may just, the next item, page 105 of 301. Is this Kyle's or?
It's Kyle's as well.
Kyle's also. Kyle. Just an observation and for some clarification, I noticed on the top of the page where it says the state versus Steve McDermott, Texas license number -G expired. I'm just curious as to why we are under the conclusion of law order education A asking him to take a use PAP course if his license is expired.
On this, this individual, he is expired, and we have to resolve the complaints. When I called and spoke to him, most of the time, people that are expired, they've moved on to whatever career and they just want to surrender. This individual told me he was looking to get back into the business. So we just wanted to make sure that we gave him some type of remedial education that addressed the deficiencies before if he decides to reapply.
Perfect. Thank you. Appreciate the clarification.
So we need a motion to approve. Well, we need a motion to approve. Aye.
I'll make a motion to approve, or Lori, do you want to go ahead?
No, that's okay. Go ahead.
I'll make a motion to approve the agreed order under 6I.
Second.
All in favor, say aye.
Aye.
Opposed? The motion carries. Agenda item number 7.
I just want to point out that looking at these enforcement matters, we're
Thanks.
finally getting old files out.
Yeah?
From 2010 is one of the complaints, and that's good to see that we're getting all these complaints, older complaints out. And also from 2007, 9, and 9. So we're moving along and getting these old stacking complaints.
We're going to be in compliance.
We should be in compliance.
Agenda item 7. The chair is naming Board Member McClendon as presiding member for hearing this matter.
Thank you, Mr. Chair. We'll be taking up agenda item number 7, which is the motion for rehearing in the matter of the SOA docket number 329133390 ALC in the matter of the Texas Appraisal Licensing and Certification Board versus Francis O. Kafour regarding the certification as a general realtor, real property appraiser, with the board denying Mr. Kafour's application. My first question, I guess, would be to see if whether or not the respondents' counsel would like oral argument.
Yes, thank you very much.
And please approach and identify yourself for the record. In this instance, what we'll do is we'll go ahead and take 10 minutes from the respondents' counsel and 10 minutes then from staff, please.
And I'll set the timer when you start.
I do not think I'll need anywhere near 10 minutes to make the few points I need to make, but I appreciate that.
Great. Thank you, Mr. Walden.
I'm Don Walden, representing Francis Kafour, and I was here back in, I think it was in early September or late August when this board considered this matter before. And I first want to say I very much appreciate this board extending the deadline to act on the motion for rehearing so that it could be considered at today's open meeting date and allow us to address this board one more time. And I filed a motion for rehearing and simultaneously with it provided to the staff of the appraisal board numerous work files that Mr. Kafour had obtained from his prior employer, Dallas Central Appraisal District. And essentially what I'm wanting, these work files are not part of the record of the case. This board has the discretion to grant a motion for rehearing and instruct its counsel, its staff to consider additional information that we may have provided, which is what we were hoping for, really. These are not part of the evidentiary record introduced before the administrative law judge. We are trying to give the staff the information that when I took over this case in late August from Ted Whitmer, I read the record and I saw, okay, they don't have the information that they said they wanted. And there seemed to have been a year of unnecessary litigation behind it as far as I was concerned. I might have done a few things differently, I think, if I had been Mr. Kafour's counsel all along. I had these work files delivered to Mr. Boyer and asked if he would consider them. Their response was that they would not consider them, not agree to any sort of settlement. because they'd already won the case, and it's like asking for a settlement after the jury returns a verdict. And I respectfully suggest, and with due respect to Mr. Boyer, that that's really not what a state agency is all about. If two people want to fight it out at 10th and Guadalupe in the courthouse and one-up each other for 2 years, and one of them's going to win and one of them's going to lose, and one of them can say, well, no, I'm not going to settle with you now because I beat you. More power to them. Let them do it. That's really not what a state agency is all about. This agency is about, obviously, as this board knows, protecting the public from incompetent or dishonest appraisers. And all we're really asking for is that after what I believe to be, looks like a year of unnecessary litigation, evaluate this man's application on the merits. We're giving you the information that we've said that we were told was lacked, and all we're asking for is that he be reviewed on the merits, on the substantive merits of his qualifications to be an appraiser. And I think that would be more in line with what this agency's mission is about. Determine whether he's someone who has the minimum level of competence and the minimum level of honesty that you need in an appraiser. And if he does, give him a license. That's what the role of the government, in my opinion, really is. And after you make those decisions, it's really to making things more difficult instead of making things more easier really calls into question to me the role of the government in this type of matter. Mr. Boyer also pointed out after I filed my motion that they still didn't have the work files for the 2 properties that had actually been requested and were noted in the proposal for decision. And we had an open records request with the Dallas Central Appraisal District pending. At the time, you can't just go in and get them. He doesn't have them in a file, as you all know, with mass appraisals. We got them, and we provided them probably a month ago. I don't know if they've even been reviewed by staff. We asked them, please look at these. Here's what you've said you've wanted. Here they are. Please consider it on the merits. And that's really all we're asking today from this board and from staff. And I'm happy to answer any questions that any of the board members may have.
Thank you, Mr. Walden. And the time that we have right now noted, Mr. Chair, is?
6 minutes has expired.
Okay, so we'll reserve 4 minutes for you for rebuttal. And before we take questions, we'll just go ahead and take oral argument from staff. And then we'll bring y'all both up and let the panel of the board members ask questions as they may have.
Thank you, Ms. McClendon.
You bet, Mr. Walden.
Good morning, board members. Troy Bollier, staff attorney. This case seems to me to be a simple case. I'm sure you've had a chance to read the motion and the response that staff has filed. Certainly the job of the agency is to license individuals. We have to do that, though, within the confines of the law. And in this case, multiple opportunities at every step of the process were given to Mr. Kafour to provide his work files, up to and including a full day-long hearing before a SOA judge. And you have the judge's decision in front of you. The motion that you have in front of you today from Mr. Kafour, quite honestly, doesn't meet the legal requirements. As you can see from my response, the first issue is the legislature has set out by statute the legal basis for granting a motion for rehearing. And that involves some kind of harm. There has to be some kind of harm that's actually occurred. And it has to have caused substantial injustice. Mr. Kafour's motion really doesn't say I didn't get a fair hearing, or I wasn't aware that I was supposed to provide this evidence, or some type of procedural or evidentiary error. He's simply disagreeing with the administrative law judge's decision and your final order. So it's really not the correct vehicle in a motion for rehearing. The second point I made in the response is that, and like I said, the black letter law in Texas, both in the statute, both in this board's own rules and the federal requirements, say that our staff is required to audit these files. We have to request work files and ensure they're in compliance. This is not a case where the record shows that staff was unreasonable and didn't make that request, or that there was any type of confusion. The record and the findings of the judge make it very clear that even in the beginning, when he first filed his application, when he filled out his log, he was at some points even swearing under oath on affidavits, I understand I have to be able to produce these. He had correspondence from staff, phone interactions with staff if, form letters being what they were weren't clear enough. All the way into the litigation process itself, a summary judgment motion was filed where Mr. Kafour's attorney represented he was attempting to get those files. So there have been multiple opportunities here to resolve this. The bottom line is, though, the board has a rule, and there's statutes in federal law, and the rules actually say you have to provide your work file within 60 days. Well, we're long beyond that. And as I've said in here, agreeing to grant this rehearing, I think would raise a concern in terms of whether that's proper action. The phrase the Texas Supreme Court uses in the response I gave you is, arbitrary and capricious. When we've got a board rule and clearly defined law that says this is what the requirement is, that's what we have to follow. The final point I wanted to make, which Mr. Walden raised, is that this work files that were provided after the fact, long after the fact, are outside the record. The first ones that were provided with the motion simply were not even files staff requested. If the audit's going to have any meaning, it has to be selected by staff. Later on, I believe about a month ago, we were provided with those other work files that were the specific properties. There again, staff, after consulting with management, did not look into those files because, frankly, we had already had a final order from the board directing us that this case was resolved. Certainly, if you rule otherwise and you direct us, we'll be glad to reopen and relook at those. But I think that, as I said in the response, the board's own rules say in a motion for rehearing, you're limited to considering the record. All of this, I think the point is that it's very clear that Mr. Kafour had numerous opportunities to meet his obligations. And I think what this motion really is asking for, as I've said in the response, is he wants to be treated differently than all the other applicants. And if we're going to equally apply the law to all the applicants, we need to have a uniform standard that's equally applied. And what this board has said and what the state statute says and the federal requirements are is that everybody's going to be audited. They get a standard form letter. They have 60 days to provide their materials. And so we'd ask you that you deny the motion for rehearing because it's not proper.
Thank you very much. Mr. Walden, do you have any rebuttal? Okay. Would you start the clock again for us?
Okay. Actually, we're right on 4 minutes, so we're good.
Perfect. Thank you.
First, the board does have the authority, the legal authority, to grant this motion for rehearing. The board can grant a motion for rehearing because it changes its mind. And state agencies, I've practiced before 15 of them for over 20 years, as Ms. McClendon knows, and they do it probably 3 times a week. The board, if it wants to, we've just stated in our motion that the board erred in adopting the proposal for decision. And if the board wants to grant the motion for rehearing and instruct the staff to take any particular action, it has the legal authority to do that. And there's no way any district court in Travis County would ever reverse the board for doing that, in my opinion. And finally, just if Mr. Boyer's arguments are going to be accepted, I just don't think it smacks of we beat you and we're not going to consider your the materials that you've given us simply because we can. And it doesn't seem right. It doesn't seem like to me like the proper role for the government. And that's all I have to say. Thank you.
Thank you, Mr. Walden. At my discretion, Troy, I'm going to ask if you have any rebuttal to what he just said, and I'd like for you to keep it very, 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 very to a minimum, just on the rebuttal.
The only thing I would say is this is not about staff simply saying we've won. What it's about is treating all applicants the same, equally applying the law that's found in the board's rules, the statute, and federal requirements.
Thank you. And where we'll proceed now, thank you all both for your arguments. Where we'll proceed now is any board member that has any questions for the council, because the parties are both, well, our party, of course, is represented, but Mr. Kafour is represented by council. So our questions would have to be directed to the attorneys. Do any of the board members have any questions for them? Okay. If y'all both want to approach, please, so that you can be heard. And Mr. De La Garza, if you'd like to ask your question.
Yes, Mr. Boyer. If the motion is denied, can Mr. Kafour at a later time reapply and start his application over again?
Yes, sir, he can.
Okay, thank you.
A response?
My understanding, and if I'm incorrect on this, I hope somebody will correct me, that there's a 1-year waiting period.
Yes, I believe, I think it's in the board's rules that you have to wait from 1 year from the date on which the application is denied. After that, he would be able to apply.
And that's, Your Honor, the primary reason I filed the motion for rehearing rather than just say, okay, we're going to start over with a new application, because I knew we'd have to wait a year.
And if I could, just because this is one of the first times this board has gone through a motion for rehearing where we're actually taking oral argument and that sorts of thing, if you could frame your questions as best as you can to the motion for rehearing, which I think yours certainly falls under that, but if we can keep it to the matters that are in the motion for rehearing. Are there any other questions? And I certainly didn't want to put a chilling effect on questions, so if I did that, I apologize.
Mr. Walden, hearing your testimony, you're wanting a motion for rehearing because now you have come up with the evidence or new evidence that was requested by the staff during the application process. Is that, and that's what you...
Yes, sir. We've given the 2 appraisals, or the work files for the 2 properties that were requested back some months before my involvement, I understand. And I think there's a proposal for decision reflects.
So if staff were to go pick another 2 properties that happens to be with the Dallas County Appraisal District, what happens then?
If I needed to, I'd personally drive up there and get them for you.
Okay.
If that's what you wanted.
Mr. Walden, that I'd address real quickly. To me, this is a real black and white type of thing that we want to do the right thing, and I don't think anyone wants to not allow Mr. Kafour to get his license. And so, to me, it just it's very simple. You know, in life, whatever we want to become, we have to go through certain steps and procedures, and it just appeared that not all of it was met. So what I'm hearing now is that specific appraisals on a specific, you know, not a very large area, but you can provide that information.
I'm sorry, I'm not sure I followed exactly what your question is. Can I provide you with...
And I hate to do this to you, Mr. Walden, but we need you in the mic. We're recording, and we have folks with hearing issues that it's projected better.
I've been told I have hearing issues too, so I understand.
By your wife, right?
Basically, what I'm asking is, I'm kind of just following up with Mark McAnally over here, is that you can basically provide the 2, you have provided the 2 that...
Yes, we've provided the 2 that were at issue, were originally requested, and the proposal for decision said, you know, their evidence showed staff requested these 2 appraisal work files and that they never got them. We've provided those. And I think what I was trying to say to Mr. McAnally is if the board instructed its staff to request 2 random other files, we'll provide them. Okay. If I have to go get them myself, I'll go get them.
I don't understand why, why that didn't happen the first time. But
I wish I could give you a good answer to that. I know what I would have done if I would have been representing Mr. Kafour, and he was following instructions of his counsel, and I wish I could give you a good answer.
Basically, what we're getting at then is that the requirements can be met.
Yes, and as far as I see it, I think they have in terms of, I mean, I know Mr. Boyer objects to the timing of why they didn't get them before, but they asked for the Ridgehaven and the Grumman properties. I think those are the 2 names of the street. And we've provided them. And we're asking them just, can you please consider these and judge us on the merits?
Okay. Thank you.
Does any of the other board members have any questions for either of the two attorneys here? We will, if not, we can go into discussion among ourselves. And I guess if we need y'all, it wouldn't be, do you, go ahead.
I have one more question. When was the application denied? When was it actually denied? Troy, do you know? When was the application actually denied?
Let me look in the proposal for decision here. I want to say that it was February of 2013, but let me make sure.
I believe on page 133 of 301, it says on February the 4th, 2013, staff advised Mr. Kaffour that it was denying his application because he failed to provide any appraisal reports or work files to verify his claimed work experience.
That's correct.
Okay. So basically, his clock began in February of this year, his denial. So the 1 year period is fast approaching. Is that correct?
That gets into a legal question about when exactly the board's order becomes final.
But it could be argued that in February he was officially notified.
I guess it could be. I guess the question is, the board took action and entered a final order in August. Is that final until this motion for rehearing is resolved? I might say that at the earliest it would be August of 2013 when the final order was entered, if not here today after the resolution of this motion.
Okay, thank you.
Your Honor, if I can add, my assumption is consistent with Mr. Boyer's on how that law would operate. I was assuming in taking the action I've taken on my client's behalf that the 1 year clock would start ticking not on February 4th and probably not even in August, but when the date the motion for rehearing is overruled. I'd like to hear someone tell me that I'm wrong on that, but that's the way I am assuming, since the motion for a rehearing being overruled is the date an order becomes final under the law.
Well, and I certainly don't want to ever tell you, Mr. Walden, that you're wrong, but I would like to hear from General Counsel on y'all's position of when does the clock tick and start ticking for the 1 year, and can that clock be modified? Is it a hard and fast, or can it go back to staff's denial of the original application?
And I'm looking for the rule right now to get the exact wording, but I believe it says the date of the board's final order denying 1 year from that, which would be August 16th, but I'll let Ellen speak now on
I don't know the rule, but I believe Mr. Walden is correct. The date that the motion for rehearing is overruled either expressly or by operation of law, and if the board voted to deny it today, today would be the date, and that's when the clock starts ticking, because today would be the date that your September order becomes final.
Thank you. And I have a question. Is there any good cause exception for that? Is there any good cause exception for that? And it would, I'm sure, be under our rules and not under the APA.
I'm not aware of anything.
Okay.
That doesn't mean anything.
Troy.
I'm not as conversant with your rules as you are.
I'm not aware of.
I'm more
Like
familiar.
I don't think there's anything in the APA about that at all.
I'm not aware of any in the rules, and for General Counsel's assistance, I think it might be 153.8 or 9. I'm not certain on that, but it's the section concerning applications, I think.
While General Counsel's looking for that, since that's a question for Counsel, does anybody else, any of the other board members,
No, I'll speak after you're finished.
have any other questions for the attorneys, for the parties? Okay, seeing none, y'all can go ahead and.
Okay, but before you do take a vote or do whatever you folks are going to do.
We're going to have discussion first.
Excuse me?
We're going to have discussion first.
I know Mr. Walden, I believe you made a comment, and if I'm wrong, I didn't catch it all, about you offered the new evidence, the files, to staff, and they wouldn't look at them.
No, I said I didn't know whether they had been looked at or not.
I don't know either. However, there is a final order promulgated by this thank you, I'm not good at charades, promulgated by this board, and staff would not be allowed to basically go behind that order and look at new evidence that's tendered by any party. I just wanted to get that out and address it in case the board members heard it and had some question about that.
Okay, and I have found the provision. It says when an application is denied by the board, no subsequent application will be accepted within 1 year of the application denial. The way I would read that is denied by the board was August 16th. That's when the order went into place.
Thank you for clarifying.
Before we go into discussion, y'all can go ahead and have your seats for now, or I guess we're done with them. If we can go ahead, I did want to make a clarification for any non-lawyers or non-administrative lawyers or whoever may want this clarification. What our General Counsel from the Attorney General's office just said is exactly right. Staff cannot look at evidence now regarding our motion for rehearing that's before us. It is not necessarily the case that if we were to grant this motion for rehearing, that they could then look at that evidence. So I want to make that perfectly clear. With that comment, if we could go ahead and start our discussion, if there is any. Mr. McAnally?
I have, maybe just for my clarification, is I'm understanding they want us to grant or deny this motion based on, in their proposal, is that he wasn't properly informed. I mean, that's the only thing we can consider. We can't consider any of this other discussion about now being able to produce files, yes or no. All we're looking at, was he given the proper guidance in what he was supposed to produce?
That would be correct, Mr. Chair. And that basically is what our discussion should be limited to. Yep. Well, if there really is not going to be any further discussion on this, then I will entertain a motion to deny or grant this motion for rehearing.
You don't need a motion. You don't need a motion. You just call for the vote.
Oh, that's right, because it is a motion.
Right.
Thank you. So I'll go ahead and call for the vote. All those in favor of the motion for rehearing, say aye. Actually, if you would, can we do a roll call, just so it's clear? I was going to say show of hands, just so that we're not talking over each other.
We can do a roll call, and do you want them to say grant or deny so you understand what they're saying?
That would be exactly right.
Okay. Would you like me to just go down the line?
Yeah, if you want to start with Mr. Black, please.
Mr. Black?
Grant.
Grant the motion for rehearing?
Yes.
Okay. Mr. Carlson?
Deny.
Ms. Fontana?
Grant.
Mr. McAnally?
Grant.
Mr. Beard?
Deny.
I'm afraid I may not have clarified what I'm asking for, and
Okay.
Okay.
You want to?
I don't know if I've worded my question right. So let me just use Ms. Fontana as an example. Can you tell me what you think the ramifications of your vote just was?
I just voted to grant him a rehearing.
Okay.
Okay. And everybody's clear on that? That made their vote so far? Okay. Mr. Beard?
Deny.
Ms. Whitcliffe?
Deny.
Mr. De La Garza?
Deny.
And as a presiding officer, I believe I can vote on this.
You can vote on this?
And I would deny.
Okay. And
so if I could have a tally?
5 denies. So.
Okay, so it would be 5-4. So 5-3 because we're missing one of our members. So that motion has been denied. So I think that we're through with that agenda item, Mr. Chair, so I'll turn it back over to you for
Right.
item 8.
Moving on, committee reports, agenda item number 8, report by AMC Advisory Committee.
Mr. Chairman, thank you for giving me an opportunity to bring you up to date. On November the 4th, 2013, your AMC committee, consisting of myself, Sarah Oates, and Larry McNamara, attended the meeting. The meeting was also well attended by several industry and public members as well, public people as well. We appreciated having board member Ms. Fontana join us as a guest at that meeting. The committee received a software presentation and essentially created a list of outstanding issues for future action by the committee. Those would be abbreviated by discussion about disqualification issues of appraisers off of AMC lists, future audits of AMCs, discussion of a recovery fund, propped payment, and the committee considering the development of frequently asked questions for guidance for AMCs. We do have plans for a future meeting in February, and be happy to answer any questions that the board may have.
Any questions? Hearing no questions, we'll proceed to agenda item 9, report by Enforcement Committee.
Thank you, Mr. Chairman. The Enforcement Committee also met on November the 4th, 2013. That committee is made up of myself, Ms. Fontana, and Ms. McClendon. Several staff members were in attendance at that meeting, as well as several members of the public. The committee had extensive discussions regarding definitions, and the committee continues to work on a flow chart for the complaint process so that we can publish it on our website. You do have 3 items on your agenda today related to committee-specific recommendations. Those would be items 18, 17, and 21. They relate to jurisdictional exception, complaint processing, and regarding appraisal logs and sponsor signatures. Mr. Chairman, I appreciate the opportunity to serve in the capacity as the enforcement, and I'm personally pleased with the hard work and the progress by the staff and the committee. If you have any questions, we would probably most appropriately take those up at the appropriate time if they deal with agenda items, but we're happy to discuss anything else listed in the report.
Any questions? Agenda item 10, report by Education Committee.
Yes, sir, Mr. Chairman, Luis de la Garza, Chair for the Education Committee. First of all, I'd like to...
Is your mic on? Yeah.
Okay, Luis de la Garza, Education Chair. First of all, I'd like to go ahead and thank the people that are working on my committee, beginning with yourself, Mr. Chair, and then Keith Kidd are the board members, but the staff that's with us that attended our meetings is Carrie Galvin, Tony Slago, Gwen Jackson, and Jennifer Wheeler were present at the meeting. And we also had Joe Wolfer from the FACT organization in attendance to this meeting. It was a very good meeting in that we made progress on it. And I'd like to go ahead and read a little bit about what we did. The Education Committee met to discuss and develop a rule and course approval from the implementation of the Appraiser Trainee and Supervisory course to meet with a new AQB 2015 criteria. The board must have such a course in place prior to January 1st, 2015. The committee has an item on today's agenda, and which we'll be presenting a little later on, for the purpose of such a rule and course approval, in hopes to have the course guidelines in place to allow course providers adequate time to develop, submit, and receive approval for the course before that date. The committee is also studying the viability of a Texas-specific continuing education course regarding TALCB's mission, jurisdiction, statutes, rules, and policies that differ from USPAP requirements. This course is not required by AQB, but could provide appraisers with valuable information. The committee will continue to study this idea and will bring a recommendation to the full board at a future meeting. For the board's information, a draft of the proposed course outline of the Texas specific course is attached to this report. And I'd like to thank all the staff and committee members on that we have here. And what we have is, we have a, if we could go to the next slide. That's the Texas core, that's the Texas course that we're looking at. And believe it or not, the Texas course is more difficult to develop than the AQB course that we're working with. We have some guidelines that we're working with. At what point can I introduce the proposed rule? During the rules, when we get to the rules, and we have a very good draft that we're going to be presenting to the public for their comments, which I think we've done a good job, because we've taken, Mr. Chair, we've taken the AQB components and we've added the Texas component into this one appraiser and trainee course. It's going to be outlining and bringing information to both parties, what their responsibilities are, and we'll be complying with the AQB mandates that they're giving us. So we're moving full steam ahead. I'm hoping that we can get this proposal brought in today, and by our February meeting we can have it adopted, and so that the providers can start working on the course, and we'll have it hopefully way before a year's end, and ahead of a whole bunch of other states that are working on this. And as a second comment, we're also working on the Texas course, and we're doing that so we can also bring general information to the appraisers. One of the struggles that we're having is do we make it a mandatory, or do we make it a volunteer type course? How much credit? How much do we charge? These are all the issues. These are all questions that we're still working within the committee to come back. And once we have a recommendation, we're going to come back to the full board. But we have an outline already that one can already start to look at. And this is the content of the Texas course that we're looking at. And I think it's a very good course. It's informational for all appraisers. And at this point, like I say, we're still debating it. And if anybody has any comments, to please contact our offices for any comments on either. And well, the proposed AQB course was one thing, but the Texas course also. So we'll be continuing to work on that, Mr. Chair. If there's anybody that has any questions.
Great. Yes.
I have a couple, Mr. Chair. I think my mic's. Am I on?
Yes.
Okay. I really am grateful that you've got the education committee going at the level that you are, and under the direction of our chairman, of showing this as an important leg of our organization. Because when I first started on this board, along with Ms. Montana, this really was not what we were shown as part of the, did I say Montana? Okay, Fontana, that's how I remember it actually, where I want to be.
Montana.
When we first came on and were given a notebook, we really saw that enforcement was the key, that we were under. Kind of the org chart just showed all the enforcement folks that were there, and it is wonderful to see the education becoming as important as the enforcement, and I think we'll see enforcement come down. And Ms. Whitcliffe may have already said this, and I'm not sure, but we had talked in our last enforcement committee meeting about a joint working group with the education committee, dealing with education on, you might help me out here because my brain's a little fuzzy on that.
Yes, ma'am, we have been having conversation, and in fact they have incorporated some of that, I believe, in the outline that I see in the education summary that we have here. So yes, I do believe that the Enforcement Committee will have some recommendations to education on things that we're seeing as reoccurring issues, and I look forward to having that joint meeting someday.
Yes, and thank you very much. We continue to modify this Texas course. One of the main objectives is going to be bringing attention to the appraisers about where are the violations, what are we targeting, what are we looking at, what are some of the things that we're doing wrong in the state of Texas, and what is enforcement concentrating on. Let's educate our appraisers to say X item is consistently being violated, and we need to address that. So we can go back to our providers and tell them, you're not putting enough emphasis on this because we're finding that this violation continues to occur in our USPAP violations. So this is something that we want to integrate into the course of bringing in not only that, but with case studies and the complaint process and what it is and what everybody needs to do. Make it an educational course, an informative course for all appraisers across the state of Texas.
And then again, my last comment about the education part that I'm not sure if y'all have had the opportunity to address, but it is a concern I think we've had in enforcement. So again, back to kind of the joint stuff is when you're informing, I know a lot of your education goes to the providers of that education, to the appraisers, but we do have an issue, and I think the commissioner can help me here or correct me, but that when we have staff that goes and gives presentations on some of those enforcement issues that are repetitive, that they can give those presentations, but credit is not permitted under certain ethics statutes or whatever, that hopefully we can work on those somehow resolving it, that our staff can have the actual reach out and not just have to go through the providers.
That's some of the logistics that we're working through right now, and we're talking about working with A&M through the Real Estate Source School to see if we can develop a course there. There's still a number of issues that we're still discussing, but we're hoping that we can get some comment on at least the outline that we're starting to provide, and if it's a good outline, and if it's something that one of the things we're debating is should it be a 2-hour course, should it be a 4-hour course, 6-hour course? Who's going to develop it? Do we do it for a fee? Do we make it mandatory? Do we not make it mandatory? I know what we want to do, but we're working through the logistics right now, and I think staff is providing some great input, and along with the committee members, and we're moving along on this quite well, actually. So thank you all. Thank you all very much for all your assistance and on the Education Committee.
Thank you, Mr. Chair.
All right, any more questions of the Education Committee Chair? Next agenda item, number 11, is staff reports.
It is barely morning, just for one more minute, so good morning. And thank you, as always, for your continued service and commitment to the success of this agency. I'm Doug Oldmixon, the Commissioner. Board member Mr. Keith Kidd sends you his both regards and regrets from his post on active duty with the JAG Corps of the U.S. Army at Fort Knox in Kentucky. He expects to be there through August of next year, but he said he plans to be here for the February meeting, and hopes that he will still be able to make the May and August meetings as well. And after 10 years of service on this board, Mr. Mark McAnally has been reappointed to represent the new Executive Secretary of the Veterans Land Board, Mr. Larry Lane. So congratulations, Mr. McAnally, and thank you for your exceptional service tenure.
10 years.
Since our last meeting in August, your staff has been busy supporting the board's advisory committees, educating the industry, and working steadily to prepare for the appraisal subcommittee visit scheduled for February. Mark Murnack and I attended the AERO meeting in Washington, D.C. in October and met with representatives of all of the federal agencies and major industry organizations to stay abreast of recent and future planned developments. We spoke to groups of license holders in Dallas recently, and also briefed the FACT Board of Directors shortly after the last meeting. We published 2 issues of the agency's e-newsletter. We staffed meetings of the Enforcement Committee, the Education Committee, the AMC Advisory Committee, and you heard those progress reports today. And today we will launch, or you will launch, the required quadrennial rule review. and your staff has begun planning for our biennial strategic planning public forums in the spring with an emphasis on education matters. I think that's very timely now. We continue to work towards implementation of the January 2015 deadlines for all of the new AQB requirements well in advance of that deadline. And also I'd like to speak a word of congratulations to Mr. Mark Lewis of Lufkin, who is an appraiser, certified appraiser of the board, who has been appointed to serve on the Appraiser Qualifications Board of the Foundation for a 3-year term. It's nice to have a Texas representative on that policy-making body. Staff-wise, we had one appraiser investigator resign and determined that to move to another agency, and determined that that position did not need to be replaced at this time. That also has the effect of bringing our budget into balance for FY 2014. We implemented a new accounting system and finalized the FY14 budget based on your action at the last meeting. Ms. Carrie Lewis, your General Counsel, accepted the position of General Counsel to the Commission, and her position is currently posted for hire. We hope to fill it in December and have hopefully a new fully trained General Counsel for the board's next meeting in February. Otherwise, I know Ms. Lewis will be available to backstop. We had a very productive orientation and training session with the board yesterday. Thank you very much for making the time to attend and for your active participation in helping to chart our future course. We continue to look for and find ways to reduce costs and become more efficient. We're implementing a new online renewal for AMCs effective December the 1st. And then we'll also launch 3 new online initial applications for appraiser license holders in January. We're making steady progress towards redesign of the architecture for the agency's website and plan to launch that early next year as well. It has been another very busy quarter, and we see the same ahead as we continue to implement the policies that you set. Your staff wishes to take this opportunity, or takes this opportunity to wish you and your families a very happy Thanksgiving and a blessed and peace-filled holiday season. Unless you have any questions for me, I'll turn the podium over to the other division directors for their regular staff report updates.
Can you just not accept Carrie's resignation and just make her work both?
She didn't resign. She was awarded a new position.
Just cut her in half.
She relinquished.
I just wanted to echo that, Mr. Chair, that it is bittersweet for us, Carrie, to have you leave us, but also go on to bigger things. So congratulations.
Same here. Commissioner, you mentioned about the website is being redesigned.
Yes.
When do you forecast that might be online then?
Well, it is our hope to have that up prior to the February meeting, so early in 2014.
Okay. Well, whenever it becomes available, I know Mr. Watson has done this for us in the past, but once it's working and all the bugs are out, I don't know, this might be an agenda item that I'd have to request, but he could
demonstration?
Demonstration and walk us through.
We'd be happy to do that as a part of a regular staff report. I don't think that needs to be a particular agenda item. All right. Thank you very much.
Let's see, who's up next?
Good afternoon. Lori Deanda, Director of Reception and Communication Services. First, I want to apologize for my voice. I'm dealing with some allergies, so I hope you all can understand me. If you'll please refer to the C1 report. On the first page, it includes the totals for fiscal year 2013. RCS handled a total of 218,580 calls, handled 7,284 walk-ins, and responded to a total of 63,424 emails, of which 1,054 were for TALCB. The next page includes the numbers for month of September 2013. We handled a total of 16,955 calls, 529 walk-ins, and responded to a total of 5,199 emails. I'm also happy to report that the hold time here recently has been under a minute, and we're responding to emails within 1 business day. So that concludes my report, and I'm available to answer any questions.
Thank you.
Mr. Chairman, if I may
Yes.
just make a comment, I think Lori probably knows that one of my pet peeves have been the hold time, particularly when I can't seem to remember or get direct lines through, even though I've been given them. And I congratulate you for the hold time reduction. That's absolutely amazing.
Thank you.
Thank you very much.
You're welcome.
Good afternoon. Gwen Jackson, Director of Education and Licensing Services. The first report for the ELS division is the active certifications and licenses. We finished fiscal year ending August 2013 on a positive note. Our number of appraiser trainees have increased by 209 over the past year, from 515 to a total of 724. And we finished the fiscal year with a total of 5,934 active appraiser certifications and licenses. This is an increase of 138 from what we had in August 2012, so we're continuing to see an upward trend in the number of appraisers.
That's great news.
Moving on to our next report, it is the report for appraisal management company registrations. During fiscal year 2013, you'll see that we registered 23 AMCs. When we combine totals from 2012 and 2013, we registered a total of 192. During 2013, 4 AMCs surrendered their registrations and 2 were revoked, which brought the total remaining to 186 at the end of August. In your supplemental material, or material that was handed out to you separately, you should have a copy of the AMC report through October, and that one shows that we've registered 4 more AMCs since August.
Ms. Jackson?
Mm-hmm.
On that report, the panelists, that's the number of appraisers on their panel for each.
That's the number of panelists that have paid during that period to become a panelist. They may or may not have dropped off since then.
But this amended report I have is 24,837, so that's 24,837. Well, okay, I can understand
and they
that.
can be on
They can be on more than one AMC,
yes.
so it's not an absolute count.
No.
Okay, I understand now.
Okay.
May I ask a question about the fee? Just remind me, the panelist does not pay the fee. Is that correct? The AMC pays the fee
Yes.
for the panelist.
AMC pays.
Remind me what that fee is for each panelist.
$10.
$10 per year.
$10 a year.
$10. That's a very good question. It's $10 to add and $10 to subtract. So it's good for a 2-year period. At the time of renewal, they will pay $10 per panelist for another 2 years. So it's really $5 per year.
There you go. That's what I thought.
Very, very inexpensive. If you refer to the L1 report, that report shows our application and renewal activity. The most notable items on this report include the increase in appraiser trainee applications by over 55.5%. There is almost a 9.5% increase in total licenses issued from original applications, And while our renewal activity has decreased by almost 8%, we do have an 11% increase in reinstatement activities. Your next report are the details on...
Ms. Jackson, let me, now the licenses issued for reinstatement applications.
Mhm.
Tell me why that's, what am I looking at there? Why do I have a 200% increase? And I guess what I don't know is, what does reinstatement mean?
Reinstatement are those individuals who did not renew their license timely, but came in on late renewal.
Oh, I got you.
Mhm.
Mr. Chair,
Yes.
Mr. Chair, can I ask a question? I think my button's
Now you're on.
backwards. Yeah. Gwen, when you're saying percentage, are you saying a percentage of the total number of appraisers, or are you saying the percentage of...
Change.
Thank you.
Change in year to year, yes.
Thank you.
Yeah, any further questions on the L1 report? The next report in your packet are reports on details of the examination activity for fiscal year 2012 and 2013, as well as the results for the month of August. Okay, and these give specific details, but the last report that you'll find in your packet provides a fiscal year date comparison of examination activity for August of 2012 and 2013. And on there, you'll notice that our pass rates are 72% for certified general appraiser, about 68% for certified residential, about 44% for licensed appraisers, and the overall appraiser pass rate is at 60%. Any questions on that report? Unless there are further questions, that concludes my reports for the ELS division.
Mr. Chairman, I'd just like to make the comment, as we're seeing the increase of appraiser trainees, the course that we're developing is very applicable to all these new trainees plus their sponsors. We've heard the horror stories, about some of the trainees not getting the proper credit and everything, so this is some of the things that we're looking at to implement across the board for the trainee instruction and information, along with the sponsors and what their responsibility. So as we're seeing Texas appraisers and trainees increase, I think it's a very good and timely, and I just wanted to make that comment.
Great. Thank you, Gwen.
Good afternoon. I'm Tom Watson, Director of Information and Technology Services. If you could turn to page 196, Report I-1. This is a September report showing the new fiscal year. What we're seeing in the past 3 months for web page activity shows a significant drop-off compared to last year. That drop-off really is attributable towards some special security testing that DIR was engaging in with our website and our network during last year at this time. So that's why you see a spike in activity 1 year ago today in this report. If you would normalize those particular months where they were active, I think you would find that the resulting statistics show continued strength in website utilization this particular year compared to last year at this time. So we are not seeing a significant drop that this report does imply. The renewals for the online applications, you'll see 2 additional renewals from, I believe, your last meeting, and that is for state license and the trainees, which we had implemented about that time of your last meeting. So now we're starting to see reports of transactions come through utilizing the online web services and online renewals. I'll continue to update those particular numbers as we implement additional renewals and initial applications. You'll see those on a regular basis through this report here. So with that, I'll be happy to answer any questions you might have.
Any questions of Mr. Watson? Thank you.
Thank you.
afternoon. I'm Melissa Huerta, and I'm the Director of Staff and Support Services. And I was going to give you the update on the TALCB budget status report as of September 2013. As you can see, there's nothing out of the ordinary. Our expenditures for the month are right about where they should be. We've expended just about under 9% of the budget, which is average. The funds that we've collected are a little bit shorter than what we're anticipated, and that's just because we've had fewer new AMCs than what are expected, but the spike under the AMC revenue will come in March when the renewals will start coming in for that first round of AMCs. So does anybody have any questions?
No questions. Thank you very much, Rosa.
Good afternoon, board members. Troy Bollier, Managing Attorney. Draw your attention to the Standards and Enforcement Services report. The first page there you have in front of you. You can see the past year's history of incoming complaints and resolutions, and the first few months into the new year here. Draw your attention in particular to the fact that we're now keeping track of appraisal management companies, obviously. You can see we've had 20 last fiscal year, and so far into this new year we've had 1. On the second slide, regarding total cases open, I think you can see that we've really made great strides in addressing the backlog of cases that are over 1 year old. For those of you who are newer to the board, the appraisal subcommittee, which is our federal regulatory oversight body, has a 1-year standard for resolving complaints from the time we receive them to the time that they are resolved. So this chart here obviously shows you the year in which the complaint was received. It is my expectation that by the February board meeting we will have resolved all the 1-year-old complaints by the time the ASC is here for their February audit. You'll also see on there a section regarding RFAs, and that stands for Requests for Assistance, for those of you who may not know. Those are special requests made through the state's mortgage fraud task force and are driven and directed by the law enforcement or prosecutorial agency that's requesting them. So while we don't have ultimate control over the closure of those, we do regularly stay in touch with them to ensure that as soon as they're finished with their case, we can close ours as well. The next slide of cases at least 1 year old. You can see here exactly the different categories, stages, if you will, that the cases might be in. You can see here that we have 12 that are on the agenda here today, which you've already addressed, that are over 1 year old. There is one currently set for trial, and currently working through some potential continuance issues on that. What I would draw your attention to there in particular, down the third one from the bottom, says regulatory reviews in investigation. That has been a number that has plagued us since I've been here many years, and it's now at 0. So we're really proud of that. And what that means, just for newer members on the board, simply means that a regulatory complaint, something other than a law enforcement assistance request, has been received by the agency, and regulatory review means that the investigator is in the process of investigating it. We've received the complaint and the response, and it's being investigated. And for the longest time, that was a bottleneck, to some extent driven by increased complaint volume, and to another extent driven by lack of staff resources. So we're really happy about that number. You can also see we have a number there in resolution. Just in particular, you can see it's in resolution or pending contingent dismissal. based on meeting with case manager earlier this week, I can say that 3 of the cases that are over a year old are in that negotiation stage. In fact, reached agreement on 1 just earlier this week. The remainder of those are all contingent dismissals that an agreement has been reached, and we're simply waiting for completion of those terms. And just to clarify, contingent dismissal is a somewhat new resolution tool that has been made available to staff, and all it means is that in lieu of actually taking disciplinary action against an individual, we ask them to do something in remedial in nature, such as take a course or get some mentoring from an appraiser. And within a certain time frame, if they complete that and submit documentation of it, we dismiss the case without any disciplinary action, sometimes just merely a warning letter. So that's been a tool that's really been helpful. But in short, I do expect that between the contingent dismissals and the negotiated resolutions come February, we'll have our 1-year-old cases down to below 0. In fact, when talking with the case manager and looking prospectively, once we do that, it does look like we will be somewhere in the 7 to 9 month old time range in terms of the next oldest case.
Right? Yes.
I have some questions.
Great.
I had some questions on that last slide. Troy, if you can help me out here. On the first line, the agreed orders PFD received, so that as of today, that 12 would be a 0?
That's correct.
Okay. And then going down to in negotiations pending contingent dismissal, I don't want to make your life more complicated. Is there a way, if I understood what you said, that 12 is actually 3 in negotiations and 9 pending contingent dismissals, is there a way either to footnote that or maybe even split that box to say 3/9 without it being, you probably can come up with something more creative than I can, but to me that's pretty telling of the step forward, from negotiations versus pending. To me seems like a pretty big step that you've gone. My next question has to do with the RFAs that you've got there. I know that, or I remember that under the ASC review process, anything that was like SOA that was waiting or whatever else, things that were out of our control for those, they didn't seem to take in consideration things that are outside our control. Is that also true of the RFAs?
Yes, my understanding of the ASC's view of our RFA and covert cases is they would not be counted against us for purposes of the audit because they're driven by our law enforcement partners under statutory requirements.
So is there a way possibly, again, to maybe footnote that as well? I'm starting to do some math here, and I'm seeing your numbers. Instead of saying 47, and I haven't done my math quick enough, but that number, if you change the 12 to the 0, because you knew at least some of those were going to happen today, hopefully. And then to me, it seems like the 22 ought to be, we need to know that information. I think that's important for us to know. But trying to give you all the pats on the backs where you deserve them, I like to see that number right now is pretty significantly low of where we've been.
Mm-hmm.
What was the math there, Mr. Commissioner?
4 cases.
Oh, 4 cases is the total?
Right now, that are either being scheduled for SOA, at SOA. In other words, what ASC would not give us call specially documented circumstances. There are 4 yet to be resolved prior to February.
Well, now I feel like I thought I had figured this out, and now my math's not doing that. Where do those 4 fall under?
The set for hearing and the 3 in negotiations.
Oh, that would be 4. 1 plus 3.
Correct.
So that's all I really had, Mr. Chair, is that this is one of the main things that have been a real big focus for us, and and we've come a very, very long way, and I don't know really if I should be saying we as much as I should be saying the commissioner and staff has come a really long way in responding to the ASC's concerns.
I have to agree with that. This has been, I didn't know when we'd ever see this day. This is great.
And Mr. Chairman, I echo that. Obvious, great deal of very diligent and hard work has gone on, and we very much appreciate all the effort that you put forth in terms of bringing the numbers down. It's important to the appraisers, it's important to the state of Texas, and I know it's important to you all as well, so we appreciate it.
Thank you.
Thank you, Troy. Does anybody has any more questions? Are we done, or no? You're still going. Sorry.
Yeah. The next slide here is you can see the past fiscal year's case resolutions for historic reference, and you can see that it's quite a significant percentage of dismissals. I believe that is up in some degree from prior years. And what I would say there is I think the rate of dismissals has increased because of our ability to get through the backlog. The backlog, in my mind, is indicative of those cases that probably are more problematic and have issues. So the fact that we are more current, I would expect to see a higher percentage of dismissals. Then the next slide, unless there are any questions there, is more specifics into the past fiscal year's disciplinary actions. And here you can see the vast majority of those cases where there are discipline. It's the least significant level of discipline is the way I would characterize it, about 82%. And those that actually are more serious disciplines or go through the litigation process are rather small in number. Unless there are any questions, the next slide, bringing you current to this fiscal year. Not a whole lot of data here, again, because we haven't had a meeting until today for this fiscal year, but you can see that so far we've had 19 dismissals. Slide number 7 here is giving you some idea of those cases that we have received as compared to those that we resolved. And I draw your attention in particular to the past two fiscal years there way on the right-hand side. For the longest time during the financial crisis and the years surrounding it, we were struggling with high incoming rate and low numbers of staff, and so the rate of incoming was greatly outpacing our ability to resolve. And I think you can see in the past 2 years that's dramatically changed. The red there in 2012 and 13 representative of resolutions is far outpacing now the rate of incoming complaints. If anyone else has any other questions, then the next slide here, slide number 8. I believe at last meeting, Mr. Murnack gave you a chart similar to this, quantifying the last, maybe it was the last 20 years, I believe, of sources of complaints. And so going forward, we're going to try and keep this updated for the fiscal year. So what you have here is starting September 1st up until just a couple weeks before the meeting, and you can see exactly what segments of the population are filing the complaints.
I had a question on that, Mr. Chair, if I may, or a couple of questions. Troy, on the board originated, how do y'all, I know there's a variety of reasons, but for my edification, can you tell me how do y'all originate some of these?
Well, and it probably would, going forward, be better to say staff initiated.
Oh,
but,
and that's what I thought.
And I already have that marked. But yes, the statute provides for the agency having the ability when violations and sufficient evidence are brought to the attention to staff initiate a complaint. And that's processed the same way any other complaint would be. It's just that the complaint is filed and generated typically by a staff member, and the director, actually signs that complaint form.
How do you find them, though? How do you, is it like going through, sometimes people have to submit reports and you randomly pick those?
Exactly. For example, the experience audit that most appraisers are familiar with on the credentialing side, everyone has to go through an experience audit before getting a credential. We would sample that work product, and under the federal requirements, we have to audit it for USPAP compliance. Well, during the course of that, if egregious USPAP violations come to attention, the staff investigator handling that audit might recommend to the division director that a complaint be initiated, either against the appraiser if they're already credentialed, or maybe perhaps it's a trainee and they're too new, but their sponsor had some responsibility.
Any more questions?
I did have one more. I'm sorry, Mr. Chair. I know what Dodd-Frank is, but what is a Dodd-Frank referral?
Dodd-Frank, that's shorthand for the federal legislation that was passed a few years ago, has some mandatory reporting requirements. I can't remember if it's in the statute or in the regulations promulgated as a result of that, but there are specific requirements that certain what they call covered persons, which basically amounts to certain types of financial institutions and other folks, have a legal duty if they meet the spelled out federal requirement. And I think that standard is kind of linked to whether there's USPAP violations that are impacting value. They have a duty to report that to the appropriate state appraiser regulatory body.
Good. Okay. Thank you very much. Sorry. That was all I had, Mr. Chair.
Okay. And so a Dodd-Frank referral might come from a bank or thrift?
Might come from a financial institution or one of the other persons that are covered under that.
Under this. Another question. There was a hotline that was established as a result of Dodd-Frank. Do you have any sense that that's been a source of referrals or people coming to you with complaints? Or
I am somewhat familiar with the program and have seen presentations at the last Aero meeting about it, but no, I haven't seen any anecdotal or any metrics or anything that would indicate one way or the other.
Great. Any further questions of Troy? Oh, we've got another slide. I keep trying to cut you off.
And the last slide here really is just reflective of comparing the number of licensees we have to the number of licensees who are actually receiving a complaint, and then comparing that to the actual number of individuals who have some sort of disciplinary action.
Making your point.
Excuse me, Mr. Chairman.
Yes.
The number of licensees, 6,700, is that correct?
That number, yes, that number was taken from the quarterly measures, and I think what it has to do is it might be a little bit inconsistent with the licensure numbers because of the timing of when the reports were run.
Okay.
So
we're at 5,900 on the
right
over here.
Right, exactly. And I talked about that with the legal assistant who generates these. It's purely a timing issue of when reports were generated.
No, and one other consideration is that this number includes inactive.
Oh.
So if you hold a credential or a license, but you hold it in inactive status, you can pay $50 and become active, immediately, same day, pretty much. And so this number, for purposes of measures, includes inactive, and the report that Gwen showed you excludes inactive.
That might make a good footnote, Commissioner.
Add a footnote for explanation.
That might be a good footnote for us, because that does really, you're talking about almost 1,000 difference, so I'm glad Mr. De La Garza pointed that out to us.
Any further questions of Troy? Thanks, Troy.
Thank you.
We'll take a short break.
Sure. We're going to take we will take a short break. The time is 12:33. We're going to take a 10-minute break and get right back at it. It is 12:45 p.m. and our meeting is back in session. We are on rules for possible adoption, agenda items 12 through 19. And I believe I am correct in saying that none of these rules have received any public comment.
That is correct.
And I would...
Mr. Chair, that being said, could I recommend that we take all these items up in one motion?
Is that a motion?
I would
Will you
like-
make that as a motion?
Yes, I would like to make that as a motion. I move that we take up items 13, agenda items, help me out.
12 through 19. 12 through 19.
12 through 19, thank you. My computer froze up on me. I move that we take items 12 through 19. I move that we take items 12 through 19 as for approval.
Second.
It's been moved and seconded. All in favor?
Aye.
Any opposed? Next item on the agenda are rules for possible proposal.
Excuse me, Mr. Chair, but just to, if I might just seek clarification. It was my understanding that the intent of the motion was to approve the recommendation of all of those, approve the adoption of all of the rules contained in items 12 through 19. Was that the intent of the motion and the action?
Yes, sir.
Okay. Thank you.
Mr. Chair,
Yes.
I'm not sure if it would be helpful right now, and General Counsel may be doing it right now. So were you getting ready to do some clarification? What were you doing standing up?
20.
I don't know if this clarification is helpful or not. We've been doing this for some time. We've got some new members, but I didn't know. In General Counsel, I'm happy to defer to you, but we do go through these pretty rapidly, and I think it's important for the public to know as well that these rules have already been vetted by at least a committee. They've already been published in the Texas Register, which is what the next section would be doing. Is that's the possible proposal is the proposed to publish into the Texas Register for comment from the public before we even consider adopting those. So just, and I say for clarification, it's really more for edification for the public to understand that 12 through 17 we have adopted and they are now our new rules, but they have gone through the 19. But 17 also, I mean. And then the next section is where we're vetting that to the public to please give us some information, and a lot of these have already been at a committee level or something like that. And then the next step would be adoption if that's the case. I just wanted to kind of fly through that part. I guess I wasn't looking at you to interrupt me. I apologize.
Thanks. I think that's good clarification. All right. So agenda item 20.
Carrie Lewis, Acting General Counsel. Agenda item 20 is amendments are proposed to simplify the requirements for additional education after 3 consecutive failures. And this is done for a couple reasons. One, to make it easier for our staff to make this an automated process. Right now they have to enter all this by hand. It also parallels a similar rule that's in place for the inspectors, and again, so IT doesn't have to do 2 separate things. And finally, it really doesn't affect that many people. We've had 10 since this rule went into effect a couple of years ago. Only 10 people have failed 3 consecutive times, and of those, the majority had to take the 30 hours. So it's just a simplification for processing and understanding by the people who are in this situation.
So basically we're saying that if an individual doesn't pass the test 3 times, You want him to take more education?
And that's what the rule currently says. It just, the rule breaks it into tiers, and we're just giving a straight 30 hours. If you fail 3 consecutive times, you have to take 30 additional hours of education.
I would just want to find out if the individual fails 3 times, is it because there's hardship in his family, or they've gone through something, or something happened that particular day? I mean, and I know the rule is there for 30 hours, but if they didn't have to take the 30 hours, could it be possible where they could take a 4th exam?
And I can't remember off the top of my head, Commissioner, did this come from the statute? I was not here when this was put in.
Yes, this is it's actually statutory. The authorization to do this is statutory, and it's actually encouraged by the AQB as well. I don't know that it's required by the AQB, but it is encouraged. Because I mean, if they've failed 3 consecutive times, obviously the first time you fail, you think, oh, well, I need to go back and study harder, right? And then the second time, well, after the 3rd time, it's clear that whatever they were doing isn't working, and so the remedy, the preferred remedy in your policy today, and legislatively giving you that authorization, is to say, you know, go brush up, go get some additional core education, pre-license education.
Well, I wonder if it's the instructor and not the test taker that would.
3 strikes, you're out.
Hopefully they figured that out.
Yeah.
Okay. And I did find the statutory provision. It's section 1103.258. An applicant who fails the examination 3 consecutive times may not apply for reexamination unless the applicant submits evidence satisfactory to the board that the applicant has completed additional education.
It doesn't say anything about what they have to take as long as they're 30 hours.
Correct.
Well,
correct. And then the rule that exists currently is what the board came up with to implement this, and it's just needs to be simplified for people to understand what they have to take and for processing. I'll also note that the examination provider provides us a pass-fail generally, and that's what goes into the computer. So again, that this part of it has to be done manually when they do fail that 3rd time. So,
Mr. Chair?
Yes, sir.
I'll try to redeem myself here. Move that staff is authorized on behalf of this board to submit amendments to Chapter 22 of the Texas Administrative Code, Section 153.11, examinations, as presented for publication and public comment to the Texas Register, along with any technical or non-substantive changes required for proposal.
Second.
It's been moved and seconded. All in favor, state aye.
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 Opposed? Agenda item number 21.
this is an amendment that was reviewed and recommended by the Enforcement Committee, and it's an amendment proposed to clarify that a sponsor who refuses to sign an appraiser trainee's log and affidavit for experience that was actually and lawfully acquired is subject to sanctions by the board.
So move.
Do I hear a second?
Second. Sorry.
It's been moved and seconded. All in favor, say aye.
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 Opposed? Agenda item number 22.
This is a recommendation that came forward from the Education Committee. Mr. De La Garza, do you want to
Yes.
introduce it?
This is the proposal that, thank you, Carrie. This is the proposal that we're putting for comments concerning the appraiser and trainee, and what we were discussing earlier about the responsibility. One of the things that, and just rehashing, it complies with the AQB requirements that we need to address. Plus, we've included a Texas component into this appraiser training so that they can know what we in Texas intend to do. And if there's any questions, I'd like to make a motion. I'd like to make the motion that staff is authorized on behalf of this board to submit the amendment to 22 TAC 153.21, appraiser, trainee, and sponsors as presented for publication and public comment to the Texas Register, along with any technical and non-substantive changes required for proposal.
I'll second.
It's been moved and second. All in favor, say aye.
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 Opposed? Agenda item number 23, discussion and possible action to approve the rule review plan for fiscal year 2014.
Good afternoon, Chair and board members. Tony Slagle, I'm Government Affairs for the board. Just a brief summary on this agenda item. The Texas Government Code Section 2001.039 requires state agencies every 4 years to go through a rule review process. The main purpose of it is for the agency to look at the rules that have already been adopted to see if there's further need for them to continue, as well as clarification, just a general overview of the rules that are in place. We are opening up all of the rules for the board, and because we're doing that, we developed a schedule in order to do this piecemeal over sort of a three-tiered process, and that schedule is attached to, or it's part of your book on page 253. And the way it works is you approve the rule review schedule, and then we open up the rules through that stage. So that's the item I'm presenting on.
Great.
So you need a motion for us to open the...
Yes, ma'am.
So moved.
It's been moved and second. All in favor, say aye.
Aye.
Opposed? Thank you, Tony.
And I had one comment, Mr. Chair, for Tony. When you do the review, this may be premature, but I'm afraid General Counsel may have her business, her head focused on some other bigger business than this little agency. But the rules relating to motions for rehearing and notice and final orders and stuff like that, I would offer my services on helping sync those up a little bit, if that would be helpful, so that there's not, I won't say confusion, but we did run through a little bit of confusion. So I just wanted that noted now, because later I may forget, and I just want you to know that I think that we can make some progress on that without any statutory changes or whatever.
Yeah, and if I may comment, Carrie Lewis again, what the motion is, there's two items that he's presented, but what the motion is to submit the plan that's attached to this item to the Texas Register. That puts the public on notice, and the public can also send us comments on any rule in that chapter. And we often get this, have you ever thought about doing this, or this needs to be changed? They don't have to give us the exact words, but they can tell us that. And at the same time, board members, for the instance that Ms. McClendon just said, can send us any comments and instructions, and it just focuses everybody on the same chapter at the same time, which is very helpful. So I just wanted to add that. So if you don't mind, the so moved was a little vague, so could we have a specific motion to submit the rule review plan as presented to the Texas Register?
Now, can I say so moved?
Now you may.
So moved.
It's been moved and seconded. All in favor, say aye.
Aye.
Opposed? Thank you, Tony. You're going to do the next one, too?
Yes, sir.
Agenda item 24.
Okay. Agenda item 24 is based on the rule review that you just approved to be published in the Register. We're recommending opening up TAC 22 Chapter 155 and TAC 22 TAC Chapter 157 for the official rule review process for those two chapters.
Mr. Chairman, I move that staff is authorized on behalf of this board to submit the review of 22 TAC Chapter 155, rules relating to the standards and practice, and 22 TAC Chapter 157, rules relating to the practice and procedures, to the Texas Register for publication and comments.
Second.
Okay, it's been moved and second. All in favor, say aye.
Aye.
Opposed? The motion carries.
Thank you.
Thank you, Tony. New business, agenda item number 25.
I think we have a new... Don't we have a new outline? Am I...
No, they just added to the end of the agenda, so we're not quite there yet.
Agenda item 25 is forms.
Oh, I thought he said new business.
It's under the title of.
Thank you. I haven't had my lunch break, I guess, is part of the problem.
We're getting close. If there are no questions or comments on these proposed form, I would entertain a motion to approve them at this time.
Well, you got a motion?
That's fine. Is there a second? He does have comment. Is there a second so we can be to discuss?
Second.
Okay, now.
It's been moved and seconded. All in favor, state aye. Well, we got to do the discussion. Sorry. So, okay. Sorry.
Mr. Chairman, can we just kind of, what is it that we're doing here so the public can understand that what we're doing for this agenda item?
There have been a number. I think it's relatively easy. You may can pop a couple of the applications up there, but it looks like to me.
I'm sorry. If I might interrupt, I can present the forms to you, which may make it a little bit easier for you. Okay? Staff.
You want to have it, Luis, do you want to go through every form?
Well, not through every form, but I can.
Or do you have just a synoptic version of it?
But can we at least title what forms are we addressing? Maybe at least that.
The forms that we're addressing are forms A through J, and staff conducted a review of the instructions and the information required in the application process in preparing for appraiser applicants to be able to apply online. So this included giving the forms an updated look, and these are the result of that review. The online application and instructions will be based off of these forms. Now, the current form is behind the proposed new form in your material. We're also requesting authorization to add the $20 paper filing fee under Rule 153.5A22 to these forms 30 days after the forms are available for online submission. Forms listed at I and J are the credit for military experience form and the supplemental form for military spouse, and these new forms were created to comply with provisions required by Senate Bill 162 and set out in amendments to 22 TAC Section 153.9. And staff recommends approving the forms as presented and that you authorize adding the $20 paper filing fee 30 days after they become available for online submission.
Could you Mr. Chairman,
yes.
Could you please just list or just go over all the applications that we're looking at right here for the
Name
public?
the forms for you?
Yes, please.
Okay. Under A is the application for certification or license by reciprocity. B is the application for temporary non-resident appraiser registration. C is the request for extension of temporary non-resident appraiser registration. D is the request for inactive status for currently certified or licensed appraisers. E is the appraiser continuing education extension request form. F is the change of contact information. G is the appraisal experience log instructions. H is the certificate of license history, active licensure, or sponsorship. And I is the credit for military experience. J is the supplemental form for military spouse.
Thank you, Glenn.
So, any further discussion? It has been moved and seconded. All in favor, say aye.
Aye.
Opposed? Agenda item 26.
Mr. Chair,
Yes.
if I could, that motion was just to approve the forms. If we could have another motion, I would suggest another recommendation was that staff be authorized to add the $20 paper filing fee to these forms 30 days after they become available online.
I think that was part of the motion. It was.
Mm-hmm. It was part of the motion? Okay, because I thought it was just to approve the forms.
It was all of it, yeah. Yes. Mm-hmm.
So we're good, huh? Okay. Agenda item 26.
Yes. That's the discussion and possible action to remove from use the request for inactive status for expired certification or license within 6 months of expiration date form. And this form is no longer needed because appraisers whose certifications have been expired less than 6 months must submit the TALCB renewal form, which already provides a box for them to check if they want to return to inactive status.
Mr. Chair?
Yes.
Mr. Chair, I would move to remove the use of the request for inactive status form.
Second.
It's been moved and seconded. All in favor, say aye.
Aye.
Opposed? Agenda item 27. Oh,
Would you like me to take this up?
Discussion of possible action regarding clarification of board policy regarding per diems and reimbursement of expenses.
I can take this up if you'd like.
I don't know who. I forgot.
It was an item that was requested at the last meeting that would be put on the agenda, so it's a board discussion item.
Great.
It looks like I'm going over here to speak, but instead I'm going to pass this out to everybody. If I can really move, maybe, Mr. Chair, if I can give you a few of those to pass left and right. On the top, you'll see
Did you
what
get
the
one?
statute currently reads. And if we find it necessary, which it appears we do, who's going to help? I have proposed policy language that mimics. Do you have one?
Yes, ma'am.
What were you raising your hand for?
For him.
Sure, you have one? As we know, we are entitled to our $75 for any day doing business. I think, at least from the Enforcement Committee point of view, from Enforcement Committee participation on my part, we do a lot more work than just committee meetings and board meetings, and we are entitled to the $75 for any day that we do any business. In fact, I think there's been times we've been over at the Capitol. I am not suggesting that I would necessarily expect $75 for a day that I would pick up the phone and call the chair of the Enforcement Committee to put something on the agenda. What I would like to articulate is that we're entitled to $75. May not be anything to some of y'all, may be a lot to some of us. But the point is, we need a mechanism so that staff gives us the check without us having to do an invoice. Right now, my expenses, staff is wonderful about. They know how far it is from my house to here. They have a direct deposit into my account, and I get those. The commissioner has said before that there has been a policy of other board members, other boards before us, that said they only want reimbursement for the board meeting, the quarterly board meeting. I would argue and feel very strongly about this, that they are not entitled to do that. But each of you as individuals are entitled to opt out and give your money to a dear charity if you'd like for assignment of that, or just say that you don't want the money and leave it for the commissioner to spend. That being said, I don't think that a policy is necessary, but it obviously, we need something to override this, what I have never seen as the policy, but an unlawful move of not paying us for our due statutory reimbursement.
So do we, okay, somebody's going to have to help me out here, because if this is a statute, how do we address this? Do we have to do a motion, or?
Well, actually what should have happened, since days well before me, days well probably before this commissioner, a check should just be issued to us. Now, if staff wants to make it difficult, they could say, y'all need to fill out an invoice every time to do it. I think we do that for PIC, that if they want reimbursement, they have a form. I would suggest that we just direct the commissioner to make sure for each committee meeting and for each board meeting that they know that we attend, that we are deposited $75 per meeting. And if any of y'all don't want it, you get with the chair in writing so that these policies that are out there, we know that they exist and there's a recording of those policies. And we can make sure, I think it's more important to give it to the chair so the chair can figure out who is getting those per diems or who is not, so that there's no misunderstanding. There needs to be someone at that level. So in a nutshell, I would suggest we don't need a policy. We just need to instruct the commissioner to abide by what the statute already entitles us to do.
If I might just clarify a couple of points that were made. There is a written policy, and as has been stated many times, history does not equal policy. But until the board takes action to change what they've adopted as policy, so I think there should be a directive of some kind. But the existing policy does not prevent the claim, but it does the claim for a per diem or for reimbursement of expenses. The statute clearly authorizes it, and it says it is entitled to receive, and I understand that. I think the history of the explanation of the dividing line between which were paid automatically and which were paid upon request simply reflected the constrained nature of resources of the agency, and clearly it says in the statute, it says in the policy, was not a preference or a bar of any kind. It simply just it did require, and I know Ms. McClellan and I have had this discussion, and she feels very strongly, and I think the board is in a position to direct this, to move that line and change the policy from which ones are to be done automatically and which ones are to be done upon request. And it's very easy for the board to direct the staff to say all of them should be done automatically, and that would be a new policy.
Mr. Chair, it appears under this commissioner, then we do need a policy. Because we don't need a policy, but since he says one exists and it's in writing, and that'll be for my new agenda items I'd like to be put on the agenda. No board can keep me, no single person and no vote can keep me from getting my $75. And I am not just speaking on behalf of myself, in case y'all can't tell. But the policy I was told but have yet to ever see, not questioning whether it's there or not, but I was told the policy said it was only for board meetings. What I am saying as a fact is that that is an unlawful policy. You cannot vote for me to not get money for a committee meeting for $75. It's not an opinion. It doesn't matter what our budget is, and I know for a fact that the commissioner has told me on more than one occasion that the policy this board voted on supposedly was that I was not entitled to my $75 for a committee meeting. So with all that said, why don't I would like to make a motion to see whether or not the board believes the policy is needed. Regarding the statute.
Okay, so the motion is to see if the board thinks a policy is necessary to enforce the statute.
Yes, sir.
It's been made and seconded. How about this? Is there any discussion?
Yes, Mr. Chair.
Yes.
I personally do not think that there needs to be a policy, as Ms. McClendon has already addressed. We already have the statute. I would like, just for clarification and for the talking point, to suggest that just because we do not take these $75 into personal use does not mean that we also cannot direct staff as to how they might use our $75. Is that true? As like maybe a budget item thing. If we wanted to not take our $75 per diem, could we, in the direction to the chair to say we don't want to take it, could we also let you know that we'd like it to go to a particular budget item?
If I might weigh in on that, I think there are two things. One is I obviously didn't clarify what I attempted to clarify, and that is there's not a policy, and there never has been, to refuse to pay any expense. There's never been an illegal bar to the reception of a per diem or expense. The policy that was written was simply to clarify or to direct staff when the payments were to be made automatically and when they were to be made upon request. That's the only written policy that exists. The policy does not in any way say that someone is not entitled to, because obviously that would clearly be illegal, because the statute says you're entitled to receive. Now, and I would leave this to, so I hope that part is clear, but I would leave it to General Counsel to research the answer to the question. If you're entitled to receive it, does that mean there's a correlative right or a further right for you to direct how it's to be used, or it's just to be received? In other words, if I can give it to you, I mean, you're entitled to receive it. What you do with it is your business as far as donations or anything like that. But don't know, I think it would require some research by General Counsel to answer the specific question, rather than say, I don't want to receive it, but I want to ensure that it's used in this particular thing, in the education fund or the line item in the budget, that kind of thing. I don't know the answer to that.
And that's my question.
Yeah, and Carrie Lewis, General Counsel, I would need to do some research. I can think of some practical problems. For instance, well, I can tell you this, you are allowed to give gifts. Anybody can give gifts, right? But skipping that step in between, we might have some IRS issues.
Which step is that?
You not taking it and giving it back. In other words, making it a very clean, here's your $75, and now I'm gifting it back to the board for this specific purpose. Totally legal, totally can do that. Skipping that step where it's not given out but you're directing where it goes creates some issues. I haven't looked at which statutes that would create, but I see problems not just for management of the budget by the board, but I also see potential IRS questions and issues for the board member who's doing that.
Yeah, well, however we need to do it to where we're within IRS guidelines and
right.
the law,
And
that's fine with me.
I'd have to research that further, okay. But I would suspect, my best guess right now would be that the $75 would have to go out and you would have to turn around and give it back in.
And I would suggest that, I didn't mean to complicate this on the gift issue. I just know that there's others that do that type of donation. And totally agree with General Counsel. You might be coming up with some IRS, actually some burden, additional burden on staff, because they have to then issue us our check that we get, the 1099 that we get, that would show that you received that and then back. So I wasn't trying to make this burdensome on staff. In fact, I was trying to make it just a known fact that we're following the statute, and if the commissioner needs us to say we're opting out, then you take the burden on yourself as a board member to opt out instead of putting the burden on me to have to opt in for it. But I love the idea of the gift. I mean, that's why I threw that out. I know that the other boards do that, but I don't know if any other state agencies do that.
Mr. Chairman, Shannon, for clarification, are you talking about just the board meeting or any time that there should be an automatic? Because I'm not just I want to clarify what your intent is.
Well, and I think you raise a good point, because I think as the commissioner continues to say, I didn't clarify, so let me try again. I didn't clarify, let me try again. He has told me on more than one occasion that I cannot receive the $75 for a committee meeting. okay? Under the statute, I can receive that, for whatever reason he thinks, policy, whatever. So what I'm suggesting is that we get paid for our committee meetings and our board meetings. If someone takes we were talking about in our committee, the chair of TRAC was talking about how she went on some public forum in different cities. I would imagine that would be one of those instances. I don't think that should be micromanaged. I think it should be staff's responsibility, like it is in every other agency that I know of, that they know when we've conducted business meetings. And if we haven't, if they don't know about it, when 3 of us may have gone over to the governor's office and think, man, that blew my entire day of billable hours, I want to make sure I get paid for that. I'm not saying I would. I'm just saying in the instance where the commissioner or staff wouldn't know that took place, then I think it's upon me to ask for that. But in general, what I'm referring to are the obvious open meetings that have been published.
Any further discussion?
I would just like to offer one additional comment, and the policy that is in existence, and so that's the reason I would ask for the board's direction as to, I can go and rewrite the policy, but whatever and there's some good language that's offered here as a policy, and that's fine. That's good because there exists a board policy today. I think the board needs to either repeal the policy or redirect it, and that's fine.
And Commissioner, that's what the motion is that there should be no policy. That's what's on the table.
Okay. If that's what that's not the motion that I heard, but that's...
You're right, whether we should vote if there's no policy. Why don't you let us have our discussion on that?
So the only correction is, or the only additional information that I would provide to you is that a copy of that policy is in your orientation manual.
And then I said opt out.
Okay. Any other discussion?
Could we repeat the...
Yep. We better restate the motion.
Restate the motion.
You want the motion maker to?
Yes.
The motion is for us to vote on whether or not we believe the board needs a policy to get paid our entitled statutory per diem.
And that's been made and seconded.
And we've been in discussion, so I've heard the words. There is a policy. I guess I'm just not clear, and I don't have an orientation manual in the room. Does someone?
No, and it wasn't given to you anyway.
So, again, for clarity, there is some policy that exists?
According to the commissioner.
And is it in conflict with the statute?
I wouldn't know. I haven't seen it.
I do not believe that the board established any policies that are in conflict with the statute. The policy as it exists simply directs staff which reimbursements to pay automatically without any further request, and that's the official board meetings, and then all other requests are in the policy. It says any other requests have to be made in writing, and I explained why I believe that policy to have been promulgated by the board in that manner. But it certainly can be changed to become automatic across the board. I understand that.
It also could be that we don't need a policy because it is already written in black and white.
And then the only thing I would ask for clarity is that the board simply repeal the existing written policy.
Okay. All right, so we're going to take a vote on, if I understand, I think I'll try to restate it, and maybe, or if somebody else wants to restate it. we're asking, the motion that's on the floor is, do we need a policy to address per diem reimbursement?
And that's the reason I engaged in the conversation a minute ago. Apparently a policy exists, so the motion's fine. I suppose we can vote, but then I guess we'll have to take another action in a minute,
Right.
because if a policy exists, then we'll need to go to step 2.
And so if you vote yes, you do want the policy. If you vote no, you don't want the policy. Am I understanding that?
No.
No.
We're just, yes. But we're not acting on the supposed policy that exists somewhere.
All right. Does everybody understand?
I'm a little unclear now.
It's kind of hard.
How about I do this? How about if I withdraw my motion? I'm going to withdraw my motion to make Jamie happy, and we'll try to see if we can do it a little bit cleaner. I would like to make a motion that we do not have a policy on our entitled statutory per diem, and that we are paid after each committee meeting and any time staff knows that we attended something. Or you can, I can withdraw that one, or I don't even have to withdraw it, and you can make one. This is insane.
Let's see, repeat the motion.
I knew you were going to say that. You want to, Lori, you want to state a motion or restate what I was trying to say? I would, please.
There's a motion
You
on
have
the
to
floor.
withdraw your motion, I guess.
I'll withdraw. If you second it, I'm withdrawing.
I would like to move that we repeal the present policy made by this board that appears to be in conflict with our statute.
I will second that artfully worded motion.
Discussion, Mr. Chair?
Yes. Oh, I'm sorry. It's been moved and seconded. Discussion.
I don't believe I've seen the policy, and I don't think I can vote on something that I don't have something to read.
Let me ask you this.
Which is why I had the motion to ask if you would be in favor of there not being a policy before we repealed something, but I jumped the gun.
What if we tabled the motion until the next meeting and we asked the executive committee to come forward with a recommendation?
I think that would be delightful, and if in the meantime my checking account will show the additional $75 that have been missing from my account, I will definitely think that's a wonderful suggestion.
So then we're going to, I don't know, care if you want me.
Well, I don't even think we have to table. Why don't you withdraw and y'all just take it up at your executive?
Okay, and then we'll just note that agenda item
For executive committee.
27 has been tabled and it's been withdrawn. The motion, executive,
item 27 has been moved.
Referred to the executive committee. Okay. Agenda item 28, discussion and possible action regarding placing items on the board agenda. Now, I believe this got here because, Luis, you had a question.
Yes, Mr. Chair. I just want to make sure and clarify and that agenda items that are brought forth by a board member can be placed on the agenda without having the chair approval if a board member wants to put an agenda item for discussion. I feel that we are board members. We should be able to bring any agenda item, unless it's in litigation or it's very controversial. I think any agenda item that we would want to bring to the board pertaining to TALCB would be appropriate, and I just want to make sure that we're clear on that. that's happening.
The only thing I would add with that, Luis, is that we could place anything on there or request to have placed, and it would be placed on there is, general counsel or someone would review the agenda and make sure that it's within our jurisdiction to, so that we wouldn't be talking about my hair color or something.
Yes, it has to be related to, obviously, this item.
Carrie, can you elaborate? Didn't we talk about this yesterday?
We did talk about this yesterday. Mr. De La Garza was not there. The discussion was that currently, and the board can create a different policy, which is what I think you're going towards. Board members can call up the chair, ask for an item to be on, no problem. If the chair agrees that it's within the jurisdiction. What the other thing that we talked about, like, what happens if, and generally everybody's cooperative, and yes, good. What happens if the chair currently right now says no, or I reviewed it and said it's not in the jurisdiction, Mr. Chair, I don't recommend that you do it, and the members still wanted that item on the agenda, the appropriate place to have that discussion would be at an open meeting at an agenda item where you talk about future agenda items and actually make a motion on it and have a vote. And that's kind of where we were yesterday. I went into some other discussion about open meeting stuff, but that's not really applicable to what you're asking right now.
Right, no, yes, and thank you for clarifying that, and I'm sorry I wasn't able to attend yesterday's training meeting. I had some personal issues to take care of, but I just want to make sure that anybody that's a board member here shouldn't have to have an authorization to have an agenda item put on. If I want to discuss budget, if I want to discuss enforcement, if I want as an agenda item, I should be able to do it without it having to be authorized by the chair. And I just want to make sure that I'm clear on that, and that's the policy that we are following. Is that correct?
I think our policy currently is, no, that's not the current policy. I think the policy currently is.
Yeah, and again, I skipped this step, but the board has a rule that you follow Robert's Rules of Order.
Right.
And so the chair generally controls the setting of the agenda and the prioritizing, because somebody's got to do that.
Yes, and I don't have a problem with that.
And then if the board member wants something, they call up. But I don't think that there's a specific policy right now, my understanding, that a board member can have something put on the agenda if the chair doesn't approve it.
Well, it's happened to me. That's why. And I want to make sure that if we need to bring at the next board meeting a policy that says, and we can vote on it, that we develop a new policy that says at any time, if it's not under litigation or it's a item.
It's within the jurisdiction.
Yes, that's within the jurisdiction, that we can put an item. I mean, in the 5 years I've been here, I've maybe had one or two items. I mean, it's nothing like it. But I want to give everybody the opportunity to be able to say, well, you know what, I've got further questions in this, and I want to put it on the agenda. That's basically what I'm saying.
And I would let you know the item today is on the agenda for discussion and possible action. If you wanted to have that discussion today, you could. If you don't want to have it today, you can bring it forward yet again to assign it to the executive committee again, or put it on the next agenda. That's at the will of the board.
But because it's on the, my button's backwards, sorry. Because it's on the agenda right now for discussion and possible action, he can make a motion, or a motion can be made
That's
that.
what I'm trying to tell. Yes, thank you.
Sorry.
And so, well, then, then I'd like to go ahead and make a motion that any board member that would like to place an item in the agenda for discussion and sometimes possible action, be able to do it as long as it's not in litigation or it's within the jurisdiction of TALCB.
Second.
Discussion.
Any further discussion?
If I might just offer two insights. One is, I think, one of the reasons to run it by general counsel is to ensure that it meets the specificity requirements of notice, public notice, so that would just be wording it. So the discussion would still need to be had, would still need to take place as to how to word it so that it meets the requirements of the public notice under the Open Meetings Act. So that's just a comment.
Any further discussion? All right. All in favor?
Well, yeah, there is.
Nope.
I have one real quick point. I would like to add that in the recent times when I've requested something on the agenda, there hasn't been an issue. In fact, there has been a time I wanted something on the agenda and in a committee, and it didn't get on the agenda, and for good reason. It would have been better to be put it on the budget committee. So we kind of, I won't say negotiated, but we came to a resolution that was the best place for it. But it's not. It's going to be discussed, and hopefully it'll be discussed at a board member, once it comes through the committee. But I definitely empathize with exactly what you're talking about, and for future board members, not to feel like they're being stifled about something they may not understand or want to get flushed, like a per diem, say, that we are statutorily entitled to.
Any further discussion? All in favor, say aye.
Aye.
Opposed? Motion carries.
Nice job.
Now we're going to agenda item number 29, request for new business agenda. No, I'm sorry.
28.
No, that's right, isn't it? 29 is, so there's nothing, request for new business agenda items. I was, I'll have one thing. I was, missed the opportunity to introduce Patrick Carlson today, his first board meeting, and so better late than never to meet Patrick, and unfortunately everybody has left. Patrick, tell us, you kind of give us a overview of where you practice and a little bit of a background.
Thank you, Walker. My name is Patrick Carlson. I'm from Austin, Texas. I have a real estate transactional practice at a law firm here in town, and I'm delighted to be on the board. Look forward to working with all of you.
Thanks. Any request for new business agenda items?
Mr. Chairman?
Yes.
I believe it's probably already recorded in the record, but as I understand it, the Executive Committee has a couple of working items to bring forth, the per diem policy that's been mentioned, and I believe there was some conversation about a mentorship and or annual meeting workshop framework to establish for the Executive Committee. And then the only other comment I would have is the discipline issue that was brought forth today as it relates to the exposure on the website. If we could get that on some future agenda for conversation about whether there's some way to make it clear that the discipline has been completed. I understand that it may have to stay there, but if there's some way to maybe add a caveat, a consideration of a caveat that says, discipline completed, so that it doesn't appear that it's still an outstanding issue standalone.
Mr. Chair, if I can address that last comment by
Yes.
Jamie, I'm really glad that you mentioned that, because I think that keeps us from having to have an emergency meeting. I still think that we need to have that on the agenda for a quarterly meeting, that we talk about, what's being left up on the website. But in the interim, to avoid an emergency meeting, we can just say, whatever that discipline is, whatever word you said, it's been taken care of. Does that make sense? Then that way we don't have to have an emergency meeting if we're able to have one. Mr. Chair, may I go forward and add a few things to the agenda?
You bet.
One was the one that I Jamie just took care of for us. And I would like to have a discussion on the USPAP manuals. We learned in training yesterday that there may be some opportunity for us to get some reduced price for these manuals for appraisers, and I think the staff and for the board members actually did. Maybe we could get some information from the commissioner on that specific thing, and I don't know if there is going to be action, but at least for us to understand what our options are, because I understand these are pretty expensive manuals and they come out every 2 years. So it is a tool that we have to have, or at least I've felt like I've had to have since I've been here. And I'm not exactly sure. I'll rely on whatever council will be here to put something on the agenda for us to be investigating approaches that we can take to overcome the burden to our appraisers of not being able to get credit for seminar hours or conference hours that are being provided by our staff that are so needed, necessary, and have the appraiser world has, at least the folks that have talked to me out there, the associations are very thrilled with when Troy and the others come out and the commissioner come out and talk to them. So if we can have that as kind of an action item, I don't know if we're going to be able to get it resolved by the next meeting, but so it's on our radar. And then I think my last point, if I'm reading my handwriting correctly, is that if we could have these policies that are out there given to us so we can see what policies exist and go through them. I don't know if we want to go through each of them, but I at least want to know what's out there and how we're being controlled unnecessarily. So discussion and possible action on providing us with every existing policy in its written and signed form or voted on form, at what date, if it was back in the 1800s that it was approved or whatever.
Is there a policy manual, Carrie, that you know of, or is that like something three-ring binder type of a?
There is a policy manual, and since I've been general counsel when y'all have done a policy, I actually have a electronic file that those are in, and those can be provided. So just for clarification, I'm thinking maybe, Ms. McClendon, the item that you might want on a future agenda is discussion and possible action to review existing board policies.
To review and act on.
Review and act on, right, existing board policies.
Or get rid of
right.
illegal ones,
right.
Things like that.
So it's an item where in your materials perhaps you would have all the existing written board policies that we have, and the board could act on any of them.
Right, and I assume that those policies that y'all use are only written ones, right? So there aren't any existing policies out there that aren't written somewhere.
Right, unless, and there are two ways, and this is just in general, unless it was a board directive that was not reduced to a written signed policy, and that could have happened in the past, and that would be evidenced in the minutes of a board meeting.
And so those policies would be just, we'd have to take someone's word for them being out there.
No, it would be in the minutes.
Okay, but I don't want you or someone else to have to go through every board meeting that we've ever had to see what directive that the board has ever given to staff.
Right.
So I guess, for possible discussion is, if it's not in writing, then it's not a policy. And that this goes back to the commissioner tracking what our directives are so that we can know what those are. So I'm sure with your new promotion, we all have great confidence that you can do that. I am hoping that we can get this notebook of policies 2 months ahead of time. They already exist, so we're not asking for I'm not asking for additional work. I wanted these policies in writing when I came on board. So if we can get those out, and then we can review what needs to be reviewed or whatever else. And I didn't get to say, Mr. Chair, I got my notebook a week plus ahead of time. So it was wonderful to be totally prepared. Thank you, whoever might have done that. So
Okay.
I just these
I'll put that
policies
on.
that keep coming up, I've been here for 3 years and I learn of new policies that I know I didn't vote on.
Mr. Chair, can I just ask a question
Yep.
just for discussion? Did y'all get the policy notebook in y'all's training? Did y'all get a notebook that had the policies in your orientation and training?
I think so.
You're just not sure about the content in it?
So, I believe so, yeah.
That's fine, thanks.
I can answer that. Not every single policy is in the book. That's correct. It is in the orientation binder. And there is, to answer your question, Mr. Beard, Mr. Chair, as there is both an electronic file and a notebook with printed copies, because I asked the very same question 3 days after I got here, is do we have a policy and procedure manual? And at the time, it was in a variety of places. And so we have spent time and then ensured, as new policies were established either by the board or the commission, that they were incorporated into this file. So we certainly can provide you electronically and or hard copy, whichever you prefer, or both, the entire manual there are some commission policies and some board policies and some joint policies, if you will. And I'm happy to provide copies of that to everyone far in advance. I mean, just as a request, we can do that prior to Thanksgiving.
Is there any reason we should need commission policies? I understand joint, but is there any reason we need commission policies? Okay. It's not part of my request.
Sure. Only the ones that have bearing on constraints that might be a part of the MOU where services are provided, but under policies that have constraints in them.
I have a question of Shannon. Shannon, you had asked about the manual, the use manual that we all got one, and you're saying you wanted to know more, but what did you want to know?
Well, I'd like to have a discussion, information then discussion on, I kind of know it, I guess. I wanted it for the board. We can get these at reduced prices for like board members and for other appraisers. And the commissioner gave us kind of a presentation, very short, but a presentation on that in our training yesterday. And I thought it would be beneficial for the board to address this so we could act on if we want to. I don't know enough about the specifics, but to offer it at a reduced rate. Somehow we might be able to help the other appraisers on getting it if we mail it out to all the appraisers, so that we want, kind of as an education initiative. I don't know if that's what we want to do.
You're asking is there a limit to the reduced price that the foundation, I guess, is giving these?
Well, right now,
really, we're not discussing it. We're just going to put it on the future agenda to discuss it.
Okay. Oh, I got you. We're going to discuss if they're available.
And possible action.
And possible action. I always do discuss
Gotcha.
possible action.
Okay. So, discussion of possible action to schedule future meeting dates. Oh, are we done with new business? Everybody's had their agenda. Item 30 is discussion and possible action to schedule future meeting dates. And I know we're set for February because of the ASC. So February the 21st is our meeting, and immediately 2 days. No, I'm sorry. Okay, May 2nd. Gotcha. So as it stands now, we're February 21 and May 2. That, if there's no problems, those dates will stand.
Mr. Chair,
Yes.
if I would If I could request that staff diligently check to see what's going on in Austin on those Fridays and that weekend, so we don't run into Formula One or South by Southwest or some huge football. Oh, we wouldn't have football yet then, but so that we don't end up with a problem. I'm lucky enough that I don't have to stay in a hotel. No, I don't get to stay in a hotel because that's not a reasonable expense that I would incur. So, and I'm not reimbursed for. But for those that have had to switch hotels to less accommodating, it might be nice to have staff research those dates. And there is an Austin calendar, by the way, that has all those events.
Well, also need to check UIL because you have a lot of state track meets and whatnot, state finals in the spring.
Oh,
Okay. Is there any other business that needs to be brought before this board?
The only thing I would like to inform the board members is that you will receive, if we have your, you will receive your per diems for yesterday and today automatically. So you can be looking for that.
I will entertain a motion to adjourn. It's been moved and seconded. All in favor, say aye.
Aye.
Opposed? The meeting's adjourned, and the time is 1:51
are you going to grab
p.m. Our meeting is adjourned.